All right, good afternoon or good morning, depending upon where you're connecting with us from. My name is Craig Feifley. I'm one of the judges here in Rapid City, and I'm a member of the State Bar of South Dakota Continuing Legal Education Committee. Before we get started, I'd like to go over a few items for us so you know how to participate in today's event. Do you or a lawyer, judge, or law student that you know have a drug or alcohol problem or struggle with depression or anxiety? Lawyers Concerned for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or your visit with LCL is strictly confidential and privileged. You may call Becky Porter for more information at 605-391-5191. Becky is an LCL member, and your communications with her are likewise confidential and privileged. South Dakota State Bar members and their families also have access to the Sand Creek Member Assistance Program, which includes a 24/7 hotline. To reach a trained professional at any hour for a confidential discussion and assessment, please call Sand Creek at 1-888-243-5744. That information will be further provided to you on the chat function on our Zoom conference here this afternoon. Today's presentation is expected to last approximately 1 hour. You will have the opportunity to submit text questions to today's presenter by typing your questions into the chat feature of our Zoom call. You may send in your questions at any time during the presentation. We will collect and address them during the question and answer period at the end of today's presentation. Thank you to the State Bar of South Dakota and CLE Inc. for their support of today's program. I'd like to now introduce to you today's presenter. Our presenter today is Tim Billion. Tim is a partner at Robbins Kaplan, a Minneapolis-based law firm with offices in Sioux Falls. He practices in Robbins Kaplan's business litigation group and represents clients in a wide variety of complex civil litigation cases in both state and federal courts. In particular, Tim advises tribes and tribal businesses around the country and has worked with multiple tribes to revise tribal codes and constitutions. Tim has been recognized for his practice in Chambers USA, Super Lawyers, and the Best Lawyers in America. He is co-chair of the South Dakota State Bar Indian Law Committee, the South Dakota State Chair for the American Bar Association's Council of Appellate Lawyers, and is past president of the Second Circuit Bar Association. In addition, the Minnesota State Bar Association has recognized him as a North Star lawyer for his commitment to providing pro bono legal services. This afternoon, we are excited to listen to Tim Billion. Tim?
All right. Well, thank you very much, Judge Feifley, for that introduction. When I listen to my bio being read, it always seems like it's got to be about someone else. I can't be old enough to have an introduction like that, but I do appreciate it. And thank you, Judge, for being our host today. And I want to thank the State Bar and the CLE Committee, along with the Indian Law Committee, for arranging this presentation and making it possible for us all to get together today. We're going to talk today about the Rosebud Sioux Tribe versus United States case, litigating the Fort Laramie Treaty. And this decision was the culmination of 5 years of litigation between the Rosebud Sioux Tribe and the federal government. It was one of the biggest, if not the biggest, pro bono undertakings in our firm's history. 17 people worked on this file, 11 attorneys, 2 paralegals, 4 LAAs, and collectively it took thousands of hours to litigate this case, led by my partners Tim Purdon in North Dakota and Brendan Johnson in our Sioux Falls office, who, as for those of you who know him, may have been more of a liability than an asset at times, but we are where we are. After those 5 years of litigation, the tribe was ultimately successful, On August 25th, 2021, the Eighth Circuit affirmed a decision by Judge Lang here in Federal District Court that held under the terms of the Treaty of Fort Laramie of 1868, the federal government has an obligation to provide competent, physician-led health care to the Rosebud Sioux Tribe. That seems like a pretty simple, straightforward declaration. Well, the language of the treaty and the history behind it were anything but simple. And it took 150 years to get to the point of that declaration. So today I want to go a little bit deeper into the background of the treaty, the genesis of the lawsuit, how the litigation played out on the way to the Eighth Circuit's final decision, and what impact this has, I think, on the state of the law going forward. I'm going to approach this CLE kind of as a lessons learned or reflective exercise that I hope can be useful not only to attorneys who are practicing in tribal law or handling treaty litigation, but can be helpful and hopefully informative to anyone who's just doing litigation in general. As Judge Fifley mentioned, you can feel free to submit the comments in the chat function. Hopefully we'll have time to get to some of them at the end. I vastly prefer softball questions, but any types of questions are wonderful. 1 second here while I pull up my slideshow. All right, there we go. So I want to start by talking about the history of the treaty to set the stage and provide a bit of context. I find the history of this treaty to be absolutely fascinating. It may not be for everyone, but I was a history major in college, so this was right up my alley. And it was actually really surprising to me. I think a lot of people, myself included, had kind of a general perception that the United States really won a one-sided war with respect to the Plains Indians in the 1800s. But the individual conflicts involved were actually pretty varied, and they were certainly not one size fits all. And the more I learned about the history behind this treaty, the more I felt that I understood the context of the treaty better. So in 1851, the government and certain tribes entered into the Treaty of Fort Laramie of 1851. I'm not going to go too deeply into that treaty other than to note that it just didn't work. For one thing, it had no enforcement mechanism, and basically nobody kept their promises. So the treaty just didn't work. And the result was a slow buildup of hostilities that culminated in a conflict known as Red Cloud's War in 1866 and 1867. Red Cloud's War was a significant problem for the federal government. The United States had just gotten through the Civil War, which obviously took a massive toll on the country. Gold had been discovered in the West, and people were flowing across the middle part of the country to seek their fortune on the West Coast in the California Gold Rush. And railroads were starting to come through to connect the East Coast to the West Coast and the South. In other words, there was a lot of money at stake that depended on being able to cross the plains safely and efficiently. And Red Cloud's War jeopardized that economic pipeline. In fighting Red Cloud's War, though, the United States suffered some real military defeats and had significant trouble dealing from a military perspective with guerrilla warfare and the style of fighting used by the tribes. And the government's inability to protect people migrating to California, its inability to keep railroads working efficiently, and its inability to sort of sweep the Indians from the battlefield actually led the United States to form a peace commission in early 1868, which ultimately produced this treaty. So why is all this background important? Because this wasn't a one-sided treaty. The Sioux were actually winning this war, and so they were dealing from a position of leverage. In a lot of treaties with tribes, you see the government forcing tribes to sign treaties that were dictated entirely by the government, And that was not the case here. In these negotiations, it was actually the United States that needed peace. So the Sioux agreed to this treaty, and they extracted promises from the United States in exchange. And we'll get to the terms of the treaty in just a minute. But unsurprisingly, the 1868 treaty didn't work well for very long either. As most South Dakotans know, in 1874, Custer leads an expedition to the Black Hills. They discover gold. This leads to another war in 1876, and history marches on. And actually, there's kind of an interesting side note about this treaty. Some of you may have heard of the case United States v. Sioux Nation of Indians. That was the decision where the United States Supreme Court held that the federal government illegally took the Black Hills from the Sioux and awarded the Sioux money damages plus interest. And I think the last time I checked, the amount owed on that judgment is over $1 billion, but the Sioux refused the money and instead want their land back. And that case, that Supreme Court case, actually also arose out of this same 1868 Treaty of Fort Laramie. So in any event, I'm going to talk next about the parts of the 1868 treaty that mattered in this case. A lot of times I don't like slides that just put text up on the screen in front of you and then have someone read it to you, but my assistant was out and I was in charge of putting the slideshow together, so you get what you get, and I'm sorry for that. But in Article 13, you can see on the screen, the United States promised to furnish annually to the Indians a bunch of different positions, including a physician. And it also promised to provide such appropriations as will be sufficient to employ such persons. And that was really significant language, because not only do you have to provide the position, but you have to essentially make it possible for that person to be employed, to do the job that they are there to do. Article 4, the federal government promised to construct at its expense a residence for the physician to cost not more than $3,000. And Article 9 was basically a safety valve. After 10 years, the government could get out of the treaty, but it had to increase the amount that it paid annually to the tribes. The treaty itself is not exactly a model of clarity, but often Indian leaders, when they were negotiating treaties with the federal government, they couldn't speak, read, or write English for the most part. Many of the treaties, including actually this treaty, the 1868 Fort Laramie Treaty, the tribal leaders simply signed with an X or some other marking, individualized marking. Primarily for that reason, there's long-standing federal law that the United States has a unique trust relationship with Indians, and as a result, courts interpreting treaties apply specific canons of construction. Essentially, the treaties are interpreted liberally in favor of the Indians. Any ambiguities are resolved in their favor, and the treaties are interpreted to give effect to the terms as the Indians would have understood them at the time they were making the treaty. Those are pretty well established Indian law canons of construction. The question then became, what did the Indians think they were getting from the United States in these three provisions? Our argument was they thought they were getting health care. And of course, it had to be competent health care. No one would bargain for the right to receive incompetent health care. And it had to be from a doctor. The treaty, in a couple different places, uses the term physician. At the district court, we also argued that some other acts of Congress in the following decades played a role in further defining the healthcare obligation the federal government owed to the Rosebud Sioux Tribe. Here are a handful of them: the Snyder Act, the Indian Healthcare Improvement Act, and the Affordable Care Act. And I'm not going to read all this text to you. You can see it on the screen, but essentially, these statutes and others, in our view, as we argued to the court, reinforced a duty to provide health care and also recognized a goal to provide the highest possible health status for Indians, or raise their health status or their health care to the highest possible level. That's a phrase that you see repeated throughout a number of these statutes. I'm not going to go too deep into the facts about the level of care at the IHS in general, or at Rosebud. There are pretty widely reported statistics on the disparate health outcomes at IHS facilities around the country. I'm just briefly going to pull out a few of the local numbers that I thought were interesting, because they're limited to South Dakota, right? These are not national numbers; these are South Dakota numbers. Between 2000 and 2010, 70% of American Indians in South Dakota died before reaching the age of 70, compared to 25% of whites. I find that disparity to be very striking. Similarly, death rate per 100,000 people, 664.1 for the white population, essentially double that for American Indians and Alaska Natives. Like I mentioned, these statistics were documented in report after report, and congressional study after congressional study, and IHS report after IHS report, going back over decades. And they all pointed back to the same three problems with the IHS system. And these were the systemic roots of the problem: lack of funding, high turnover, and poor oversight. And because over time, all of these reports were identifying the same shortcomings, it meant that the problems that we knew about just weren't getting fixed. Rosebud's IHS facility in particular was really one of the worst. And there were some particular events in 2015 and 2016 that really precipitated this lawsuit. In November of 2015, some Medicaid surveyors reviewed the Rosebud Hospital to evaluate the hospital's compliance with all of the federal statutory and regulatory conditions for participation in the Medicaid program. And following that review, CMS sent the Rosebud Hospital a notice that it was going to terminate its Medicaid provider agreement because the deficiencies in the hospital's emergency room services were so serious they constituted what CMS calls an immediate and serious threat to the health and safety of any individual who comes to your hospital to receive emergency services. That type of notice is called an immediate jeopardy notice. The specific deficiencies that CMS was addressing at that time period, the one that stood out the most to me was a pregnant patient who arrived at the emergency room with contractions every 5 minutes and who was triaged as urgent. An hour and a half later, she was discharged from the ER. No explanation, no reason given. So she walked around for a bit and then went over to the outpatient department. Her contractions continued. She was told to just walk around and go to the bathroom. 41 minutes after being discharged from the ER, she delivered the baby on the bathroom floor in the outpatient clinic. I don't know, some of you may follow the Argus Leader here in Sioux Falls. There's recently a story in the paper that that patient settled her subsequent lawsuit regarding that incident. I wasn't involved in that particular case, so I don't know anything about it other than what was in the news article. But needless to say, I think some pretty compelling and egregious facts there, and an example of the type of care that was being provided at the Rosebud Hospital. Following that incident, so in early December of 2015, IHS closed the emergency room, which meant that people on the reservation in need of emergency care had to travel either to Winner, South Dakota, or to Valentine, Nebraska. And both of those hospitals were about 50 miles away. 50 miles in an ambulance, especially on winter roads, is not exactly the type of trip that you want to make if you are in urgent need of emergency medical care. Later in December of 15, the IHS hospital then reduced the hours of operation for Rosebud's urgent care unit. Later in the summer of 2016, while the emergency room was still closed, the Rosebud IHS facility shut down its obstetrical and surgical services, and diverted those patients to other facilities as well. Now, a lot of these closings were exacerbated by just massive staffing shortages. And for those staff that were there was extremely high turnover, both among staff and supervisors and executives. All of it meant that even the services that were nominally open, a lot of times weren't, as a practical matter, available to patients. We heard a lot of stories about people dying on ambulance rides while they were traveling to Winter or to Valentine. We heard people about giving birth in ambulances on those same rides. So it caused some real hardships to divert those patients to other facilities, particularly those patients that needed urgent or emergency level care. We also heard a lot of stories about IHS's referred care program. And here's how that program worked. If an IHS patient needed care that wasn't provided at the IHS facility, IHS would refer that patient to an outside facility and then pay for them to receive the care there. But because of budget issues, IHS triaged these referrals based on, I think, 5 or 6 levels of urgency, and level 1 was the most serious. And level 1 had to involve a condition that posed a serious risk of loss of life or loss of a limb. And during the relevant time period here, patients at Rosebud could only get referred care at another non-IHS facility if they were designated as a level 1. So as a result, when we were talking to members of the community there, we heard a lot of stories about how this limited care impacted people. I recall one story of someone who had diabetes but couldn't get referred care until it got to the point where his foot was at risk for amputation. That qualified as level 1. I recall another story where a person tore a rotator cuff in a shoulder, which can be repaired by surgery, but is not a level 1 condition. So rather than the simple operation that would have repaired the rotator cuff, this patient was given opioids to manage pain and became addicted. This is just a handful of examples, but were really some of the examples that stood out to me personally. So when we met with tribal members, when we were talking to people about this situation, I don't think there was any question about the nature of the care that was being provided at the Rosebud Hospital, but the question was, what do you do about it? What can you do through the legal system, through the legal process, to address that type of situation? Well, we had a treaty. We had a federal government as a defendant, so we felt pretty comfortable about being able to establish federal jurisdiction by filing a lawsuit. But the exact relief that we could seek posed a bit of a challenge to us. One of the first problems that we confronted is you generally can't get a federal court to order Congress to appropriate money. That's a separation of powers issue. So even though the core of IHS's problems was just a debilitating lack of funding, we couldn't ask a federal judge to appropriate that money for us. So without that money, what other relief was there that we could get? Ultimately, we settled on the idea that even if we couldn't get the actual appropriation of money, we could get a declaration of rights, the rights of the tribe in relation to the treaty and the federal government's obligation as trustee for the tribe. Because we're a bunch of lawyers on the line, I will talk a little bit about some of the discovery challenges that we faced, and this is where I think some of those lessons learned were particularly interesting for me. For example, we encountered some issues with 30B6 witnesses. There's not really a practical way that the fine attorneys at the U.S. Attorney's Office here or at Main Justice in D.C. could ever hope to prepare a witness with all of the knowledge that exists in the federal government, especially on a topic as broad and really technical and challenging as IHS and its funding and the types of care provided. So we went back and forth through a number of different discussions with the government, the attorneys for the government, and ultimately ended up with the government identifying individual witnesses to testify on the various topics that we wanted, but having those individuals depose as individuals rather than 30b6 witnesses. It wasn't a perfect solution, but it did allow us to get the discovery that we felt we needed and to keep the case moving forward. I think that approach, you really have to tailor it to any individual case, but is certainly a concern, not only if you have the federal government as a party, but really any type of very large organization. 30b6, as a lot of us know, is a great tool, but can be really limited when the organization gets so large or the topics get so broad that meaningful preparation doesn't exactly mean meaningful answers. So speaking of those fact witnesses too, another challenge in discovery was the staff turnover, and that was just a reality of what was going on in this case. It was difficult to find witnesses with knowledge, or at least knowledge over a broad enough period of time to really be helpful. I recall one witness in particular, we asked to depose the person who held a certain position at the Rosebud Hospital. So we got her name, we noticed the deposition, and I show up to take the deposition, and we realized pretty quickly that she'd only temporarily held the position for a matter of weeks. Right around the time we issued the notice and up until right before the deposition. So she really, she'd been a placeholder and didn't have any knowledge about anything. So that deposition ended up being about 10 minutes long, probably the shortest deposition I've ever taken. And that's only one example and probably the most extreme one I can think of, but there were a lot of other witnesses that had similar issues, right, where they were only at the hospital for a certain period of time, which meant it was really important for us to be very precise with our preparation and our questioning to make sure that we were asking witnesses questions that they could answer, that we were getting useful foundation for the evidence that we needed to gather, and to make sure that we weren't leaving gaps in the evidence. So we would have to go back and find other witnesses to fill in gaps in time if we possibly could. So it made the deposition scheduling and the fact discovery pretty complex. One of the other challenges that we faced was just this incredibly complicated and opaque decision-making process surrounding the formula for the allocation of IHS funding. And really, I think looking back on it, this issue is just going to be an impossible quagmire for us. Part of it is sort of the systemic and longstanding nature of these problems, but part of it's also the sheer size and complexity of this budgeting process. The government did try to focus on the funding issue. They argued, we appropriate a lot of money to IHS. That's sufficient to satisfy our treaty obligation, and that the outcomes are due to factors outside the government's control, such as difficulty retaining staff, difficulty recruiting staff in rural areas, those types of things. So we ended up treating it almost like a res ipsa issue. We took the position that it didn't really matter how much money was allocated to the Great Plains area or to Rosebud or to specific programs or to IHS in general. What mattered was the legal duty. And no matter how much funding or lack of funding was there for Rosebud, the outcomes spoke for themselves. And again, the legal duty was the key focus here. And because we chose not to make funding a large part of our affirmative case, that issue just largely dropped out of the case, which I think was ultimately a significant strategic benefit for us. Having gone through sort of that background and a few of the lessons learned type reflections from discovery, I want to talk about some of the key arguments that were part of the district court's decision and that were then part of the appellate process here. Both sides cross-moved for summary judgment. Our position was that the treaty and the subsequent statutes created a duty to provide health care to the tribe, and that once a duty existed, the federal government owed a trust responsibility to the tribe. And the responsibility, we argued, was to provide the quantity and quality of care sufficient to raise the health status of the tribe to the highest possible level. That was the goal set forth in the various statutes and regulations pertaining to IHS. So that was our position on the cross motion for summary judgment. The government took the position that the treaty only required the government to provide a house and a doctor. It didn't require the government to actually provide medical care. And they also argued that the government didn't owe a duty in this instance because there was no trust corpus that the government was managing for the tribe. The trust corpus issue is an interesting one. It's, trust corpus is essentially some type of property or asset that the government manages for a tribe. It could be timber, it could be oil, but when the government manages a resource or an asset for the tribe or for the benefit of a tribe, they become a trustee for that specific resource. So that goes beyond just the generic United States as a trust relationship to a dependent domestic nation. But the government relied on some cases that found that without a trust corpus, there was no free-floating specific trust duty. And that can be true in some instances, we argued, but that there are other ways that a duty can arise. Many tribes, for example, retained in a treaty the right to fish in certain waters. That's not a resource the government manages, but it's a promise the government made, and it's a promise the government has to keep, and it confers a right on the tribe. Ultimately, the district court agreed with us on that issue. The district court ultimately also rejected the government's sort of literal interpretation of the treaty that it only had to provide a single doctor and a $3,000 house to comply with the treaty. I think a big part of that was the Indian law canons of construction. We saw the treaty language before. It's not all that specific, but using those canons of construction, I think the court reasoned that the treaty provided health care, and it provided to the tribe by requiring the government to send a physician to construct a residence and to appropriate money sufficient for that physician to be employed. In other words, to practice their profession. And another part of that, as I mentioned earlier, is that the tribe, as it understood the deal at the time, would not have bargained for anything less than competent care from that physician. Now, the district court didn't agree with us either entirely. It held that the subsequent statutes that Congress had enacted were aspirational goals. They weren't judicially enforceable commitments or duties. So the court found ultimately that the treaty required the United States to provide competent, physician-led health care to the tribe. The government appealed to the Eighth Circuit and raised essentially the same arguments that it had in the district court. We changed our approach a little bit on the appeal. As I mentioned, we lost in the district court on the statutes creating this heightened duty to raise the health status of the tribe to the highest possible level. And rather than cross appeal that portion of the decision, we chose to really narrow our focus into the treaty, which was the source of our victory at the district court, and to defend the district court's articulation of that treaty duty. And I think that this strategic focus was really beneficial. The Eighth Circuit and the government didn't really have, I don't think, a persuasive alternative interpretation of the treaty. And as I've mentioned before, the canons of construction being what they are, ultimately the Eighth Circuit affirmed Judge Lang's decision. Obviously, this was a great win for the Rosebud tribe. It's not the final step. They need to take this decision because this decision doesn't appropriate any money. The decision doesn't directly fix the problems. It's not a magic wand or a silver bullet or whatever other metaphor you want to insert there. Congress is ultimately going to have to be the entity that provides sufficient funding for the government to keep its promises. But I think having a judicial declaration from one of the three branches of government is a powerful tool that the tribe can use to lobby Congress, to put pressure on Congress, to say, we have a declaration interpreting our rights under this treaty that you signed, and you have to keep your promises. But this goes from a policy perspective and from a practical perspective, it goes beyond just the Rosebud tribe. There were a lot of other tribes that were signatories to this treaty, and the Eighth Circuit decision applies to those tribes as well. So I think there can be a lot of cooperation and collaboration to use this decision to generate change to help the tribes. There is certainly a lot that this decision leaves unresolved from a policy perspective. But one thing that I think is clear is that the district court and the Eighth Circuit both rejected the government's narrow interpretation of the treaty, that it only needed to provide a physician and a $3,000 house. I think the decision also stands for the proposition that even if promises made a long time ago are no longer convenient or have been broken before, the United States can't just back out of them or refuse to follow them. When we were in the process of litigating this case, I was particularly struck by a passage from Justice Gorsuch's opinion in the McGirt v. Oklahoma decision. It was talking about reservation land, but I think it may as well have been written about the healthcare at Rosebud. And Justice Gorsuch wrote, "Unlawful acts performed long enough and with sufficient vigor are never enough to amend the law. To hold otherwise would be to elevate the most brazen and long-standing injustices over the law, both rewarding wrong and failing those in the right." One final thought I have on the impact of this decision, and I think it's particularly relevant to this audience of lawyers. Tribes are becoming more willing to use their sovereignty and act as drivers of change, right? Let's look at the last decade. Many people will remember the Dakota Access Pipeline protests in North Dakota. I have been told, though I have not personally confirmed, that those protests brought together the largest gathering of tribes since Greasy Grass, which is also known as the Battle of Little Bighorn. It's pretty incredible that so many tribes can rally together in certain circumstances. I looked at this case where the Rosebud Sioux Tribe took a stand on behalf of the treaty tribes, and it won. It used its sovereignty to take steps to force the federal government to keep its promises. I look, for example, to the opioid litigation, the MDL litigation that's going on with respect to the opioid epidemic. Our firm represented, I think, about 28 or 27 tribes in that litigation, and I think there were 400 or so tribes that signed an amicus brief in the MDL. There's a separate tribal track to that litigation. The tribes recently reached, I think it was about a $590 million settlement for all the tribes collectively that were involved in that litigation. And that will mean real money going to tribes to help them deal with the consequences of the opioid epidemic. But I think here is the key difference. Compare the opioid litigation to big tobacco. Okay, big tobacco is a similar case where states sued the tobacco companies and got these landmark settlements, but tribes weren't a part of that deal. They were left out. But here we are 20 years later, and rather than being an afterthought or an omission from the process, tribes are exercising their sovereignty, and they're exercising it in the same way that state attorneys general do. That's pretty incredible to me, and I think that's a big change. I think it's relevant to this audience in particular because if you have tribal clients or you work with tribes, I think this decision is a really good tool to keep in mind. You can use treaties, you can use other tools, other agreements in your toolbox to advocate for your tribal client. And also, if you're just looking for tribes or exploring issue or clients, don't forget tribes. Lawyers in this state in particular are really well positioned to have connections to tribes, to build relationships with tribes, and ultimately to represent those tribes. And I think as a state bar, we really have a unique opportunity to advocate for tribes, particularly given how many we have in our jurisdiction here, and to bring their diverse perspectives to the forefront in litigation and in policy discussions. I want to close for the prepared portion of this presentation with a few personal thoughts. A lot of times in civil litigation, at the end of the day, cases are just about how much money is changing hands, right? Who's bringing the checkbook to the table? They can be interesting cases, they can be meaningful cases, they can be very important to your clients. But I think a case like this, at least in my experience, was really different. I was really humbled by the opportunity to represent the tribe here. And I think it's a big reason why so many people, in our firm were willing to volunteer their time as well. A while back, after this decision wasn't appealed to the Supreme Court, we visited Rosebud to meet with the tribal council. And we talked about the end of the lawsuit. We talked about what it meant for the tribe, and looking around that room and connecting with the people there. I'll remember that moment for the rest of my career. I could tell the impact that this had on all the people that were in that room and all the people that were a part of Rosebud. So here is my charge to everyone. Do pro bono work. Under our rules of professional responsibility, every attorney should perform 50 hours of pro bono service a year. And I know that there are other demands on your time. You have to hit your billable hours, you have to collect money, you have to bring in new clients, you have to keep the lights on and the doors open. I get that you have demands from outside of work. I understand all that. And I know that when you have to start budgeting your time and triaging things that you can do, it's easy to cut the pro bono hours first. But I would encourage everyone, particularly those people starting out their careers, the young lawyers, to take that 50-hour a year goal to heart. Make it a floor, not a ceiling. And more than just the hours, take on the challenging cases too. I mean, yes, do the free legal clinics, and yes, do the misdemeanor representations, but don't be afraid of the big pro bono cases either. Two of I think the most rewarding cases I've worked on in my career have been pro bono cases, and they can take a lot of time and a lot of investment. But if you are in the position to do them, if you have that opportunity, they are really well worth it. I am very grateful that I got the opportunity to work on this case. And I'm also grateful to have the opportunity to share some of my thoughts and reflections and lessons learned on this case with everyone here today. I'm gonna stop sharing my screen here. And I will turn it over to Judge Fifley for the questions and answers.
Thank you, Tim. That was really enlightening. We appreciate the work that you did and those in your firm, as well as sort of the outline of how meaningful that work was and can be to those of us who are out and listening here today. We do have a question. That question is, thank you for your great work in Indian country. How do you think the recent Castro Huerta decision will affect relations going forward, between the tribes in South Dakota and the state of South Dakota itself?
Yeah, so that decision was a pretty recent decision by the United States Supreme Court, and I think it's growing out of the issues, a lot of the practical issues that have come up from the McGirt decision, which I think I read the quote from Justice Gorsuch in that opinion, which held that, and that decision in turn held that certain land within the state there was reservation land because Congress had never diminished the reservation, and so the state didn't have jurisdiction there. That was the holding of the McGirt decision, and there have been a few subsequent decisions since McGirt, just in the few intervening years. Castro Huerta was one of them that held the state did, in some circumstances, or could have jurisdiction. Another interesting decision was the Cooley decision, which addressed the ability of tribal law enforcement officers to stop non-tribal members on reservation roads, even just temporarily for suspected violations of the law. And I guess to Vicky's question, I'm going to take a little bit of a cop-out, which is I don't know. I think this is a really quickly developing area of the law, and I think that there are going to be a couple categories of concerns, right? One category of concerns is going to be just practical, right? Do we have areas of states where we have difficulty enforcing laws, where we have difficulty with prosecutions, and how do we make sure that we don't have any gaps that are created by sort of our formal legal structures. And another is going to be, I don't know the best term for it, but it is going to be more formal, which is going to be, I think, a press to recognize that, there are a lot of treaties, there are a lot of reservations, there are a lot of agreements with tribes that just simply have fallen by the wayside, and we're going to have to figure out what we do with those. So I don't know how specifically this sort of trio of decisions will affect relations between the tribes in South Dakota and South Dakota itself. I would hope that not just within South Dakota, but around the country, that tribal officials and state officials can cooperate to find some common ground and solve these problems themselves without necessarily having to go into federal courts for it.
Thank you. Anthony Sutton sends our next question, and that is, what is next for the tribes? Do you see any additional treaty claims that South Dakota tribes may need to consider? And concomitant with that, do you believe that the decision here will lead South Dakota tribes to consider bringing more treaty-based claims?
It sounds like Anthony has something he's considering here. I would say this. And one of the reasons that I mentioned the United States v. Sioux Nation of Indians case at the beginning of the presentation, that case involved the same Fort Laramie Treaty as the one we litigated. And so I think between that decision and the Eighth Circuit's decision here, it is pretty well established that treaty is enforceable, right? So yes, I do think you could, there could in theory be a lot of claims, right? I mean, to the best of my knowledge, I don't think that the federal government is probably providing a blacksmith or a miller to the tribes here. But a more practical question is, I think the litigation or the treaty claims are only going to arise when they correspond to a meaningful remedy to the tribe. So I think that's going to be on a case-by-case basis, not just for tribes here in South Dakota, but really for tribes around the country. I think they sure can consider bringing more treaty-based claims. And like I mentioned at the end of my presentation, I think that I think tribes have always been aware that they've retained their sovereignty and the tools that sovereignty gives them. But I think that it is really becoming a lot more common to see tribal sovereignty, whether it's in the treaty context or whether it's in the the arm of the tribe tribal business context, to see favorable decisions recognizing and enforcing tribal sovereignty really since the Bay Mills case back in I think '95. So I do think that it's becoming more common for tribes to use their sovereignty to bring claims, and whether they find those claims in a treaty or some other agreement or some other obligation, I think that it's a trend that I do expect to continue. One of the interesting things, right, about tribal sovereignty is the arm of the tribe issue, and tribes don't really have a traditional tax basis like states do. Tribes can't raise money through taxation the way that states can generally. So a lot of tribes have tribal businesses that they use to generate revenue to fund their governmental services. For a better or for worse, I mean, there are a lot of different aspects and avenues that can come up. But I think that as we see online commerce increasing, it's becoming a lot more plausible. I mean, in the past, right? People visited tribal casinos, tribal hotels, right? But now with online commerce, it's a lot easier for tribes to, I think, form a wider variety of businesses. And so I do expect that the arm of the tribe issues will be a big part of tribal litigation going forward.
Thank you. We still have a few minutes remaining. If someone would like to enter a question into our chat room, we'll wait just a second for that. All right, not seeing any. I want to make sure that Those of us that were here, as well as the State Bar of South Dakota and its CLE committee, thank you, Tim, for your presentation here today. If those in attendance have any additional questions following closing of our Zoom meeting today, you can contact the State Bar at info@statebar.net. And the bar will make certain that those get forwarded to Tim for his comment and review. Once you leave today's webinar, you will receive a survey regarding the presentation, and we would greatly appreciate if you would complete that and provide your feedback. We aim to make sure that these are meaningful for those who participate and that we address matters in the way that make the most sense for those of you that are participating. On behalf of the State Bar, thank you for joining us and have a great rest of the day. Thank you.